We have a very interesting topic today, very much on point. Very excited to have this. Frank Sudell is the vice chair of the Professional Services Group as well. So he's also a CPA, as I am, and this is interesting, though, to all professions, whether you're in business or not, because many of us have clients as well. So this is a great topic to listen to. We are going to go through the latest requirements for employers with regard to COVID-19 and the vaccination. Show of hands, who has been vaccinated? Okay, and that's going to be part of the discussion that Tina's going to go through. And we also, with the new government and change with the election and such, we're going to talk about the 2021 new beginnings, what employers need to know to protect their business. And Tina's has a lot of information to share on that. I want to go through the sponsors. We have Prime Point, Marsh and McClellan, Tryon. We also have Penn State Great Valley, Focal Point, PMA, and Tonbo Visual Promotions. So thank you all for being the sponsors this year. It's been a tough year, I know. Our agenda, we're just going to do, well, we just did it. We're welcoming and sponsor. We're going to go through the two areas. We will have a breakout room in the middle to have a question and have some discussion, and also just say hi to the people that are going to be in those rooms. We'll summary and wrap up, and then if you want to stick around for more networking, we can do that as well. And so, given that, it is my pleasure to introduce Tina Reger. I have known Tina for a good probably 6 or 7 years. She's an attorney who was with various companies, including Basil and Less and Feldman. I think I'm pronouncing that right. And then she started her own company, Law Offices of Christina Reger. She's been doing that for what, about a year and a half, maybe?
Yeah, about a year and a half.
And just in time to go into the pandemic and be on your own. She concentrates on employment law, litigation, counseling, many things from a law perspective that deal with employees, that deal with the work environment. So with that, Tina, I'm going to turn it over to you. Bit of housekeeping, everyone put yourselves on mute. There are going to be a lot of questions, I'm sure, so just use the chat, and Tina will have the chat available, so she'll try to answer those questions as she goes along, and if not, we will get to them at the end as well. All right. Tina, it's all yours.
All right, so I think you have to stop. Okay, there we go. Now I have to figure out how to share. I was never a technical person before COVID. So let me just make sure I'm sharing the right screen. Screen 2. Okay, can you guys all see that?
Wait a minute. Yes, now it's coming up.
Yes. Okay, great. Now just let me get the little chat box up. Okay. All right, everybody. So as Amy said, we're going to kind of break this into 2 segments. We'll talk first about COVID and the COVID requirements and the vaccine, and then we'll take a short break, and then we'll talk about the new laws being implemented as a result of the new administration. And grab your notepads. There's a lot of information. Please, I welcome questions. I welcome discussion. So use the chat. And I'm happy to answer questions. I'm happy to let you get off of mute, and that always makes it more entertaining as well as more engaging for all of you. So bring your questions. I'm happy to answer them. And if I don't know the answer, I will get back to you. So first, thank you to Beacon. I know a number of you on the call that are probably Beacon members. I can tell you throughout COVID, I got a number of referral from Beacon members. So I'm so very grateful to Beacon for inviting me to speak, and for the referrals and the confidence that you have in me to help your clients and friends through difficult issues. So as Amy said, I typically work with employers on employment law issues and compliance. We try to avoid litigation when we can. We try to have employers set up so that they don't get themselves in a situation that involves litigation, but to the extent that they're involved in litigation, we work through that as well. But I also have received a number of referrals from Beacon members for employees that are either working through an executive contract or a severance agreement, and I do assist employees in those two limited areas. And having done hundreds of them on the side of employers, I kind of have a very unique perspective in how I approach those agreements on the side of an employee. So just a couple disclaimers, as all lawyers always have. This is not legal advice. It's just information. It's for informational purposes. If you want legal advice, please reach out to me. I'm happy to have a conversation with you. And that this doesn't create an attorney-client privilege, and that hypothetically, I will answer as many questions that you have as I can. So with that, let's start. So where we are today, this slide changes every single day, as you can imagine. We have 1.8 people vaccinated in the state, fully vaccinated. We sadly lag very far behind most other states. I don't know why, but Philadelphia seems to be moving a little quicker than some of the outlying counties. So, and I do know people that are not in Philadelphia that are getting shots in Philadelphia, but I also have heard stories where people have been turned down if they're not Philadelphia residents or work in Philadelphia. PA has just over 1 million cases and 24,000 deaths as of yesterday from COVID. And we are still the 8th highest state in the country, which I thought was kind of surprising, but that's where we are. Okay. Current quarantine requirements from the CDC. At least 10 days from when first symptoms appear, you're supposed to quarantine. I get a lot of questions, and there has been some guidance out from the CDC that says if you are exposed and after day 5, you have 2 negative tests within 2 days, you can come back to work. But the problem with that is the testing to get the results, unless you're paying for that rapid test, takes 2 to 3 days. So I don't always recommend that as a course of treatment. I tend to be more conservative and go with the 10 days since first symptoms appeared. 24 hours with no fever or no fever reducing medication and other symptoms that are improving. Okay. Current quarantine requirements if you've been exposed. I put them all on here, but really the only one that really resonates with most people is within 6 feet for greater than 15 minutes within a 24-hour period. So when you're thinking of a work environment, if somebody tests positive, to determine whether they've been in close contact with other employees, that's the litmus test. The other ones are obviously, if you have somebody in your home that's positive, or somebody sneezes on you, or you share utensils. I don't know why anybody would do any of that these days, but those are the other requirements in terms of exposure to somebody. Two stop points is vaccinated or already tested positive. And the CDC recently has put out requirements for those that are vaccinated. The last I heard on already tested positive was 3 months for sure that they're, that you shouldn't get it again. That's their kind of shouldn't get it again within a 3-month period that you're kind of immune. But beyond that, they don't have any recommendations. They don't make any promises that you can't get it again. And there have been cases of people getting COVID again. But if you are fully vaccinated, you can visit with other fully vaccinated people without a mask. You can visit unvaccinated people in a single household that are low risk to get the disease with no mask and no social distancing. And you do not have to quarantine if you were exposed to somebody who subsequently tested positive. If you're fully vaccinated, you should continue to maintain your mask in public, social distance, and mask when you're around people that are higher risk. Avoid the medium and large gatherings. Get tested if you experience symptoms. Follow guidance from individual employers that have those individual COVID policies, and follow travel requirements posted by the CDC if you intend to travel. Okay? So what agencies to consider? What agencies do I look at or review almost on a daily basis? The World Health Organization, which we've happily rejoined as of January, the CDC, the US Department of Labor, and OSHA, which seems to be, OSHA right now is kind of the leader in terms of what I've seen over the past month in issuing guidance. In PA, there's also guidance and different sites to follow. The governor's office puts out regulations and requirements. The PA Department of Health puts out requirements and guidance. The Pennsylvania Department of Labor, the PA Unemployment Office, and then some municipalities and counties put out their own guidance. So follow those. And for those of you that have been vaccinated, you know that you register with your county in addition to trying to get the vaccine through different pharmacies and things. You register with the county, and the hope is that you should be getting a call from them as this is done on a county level. So, okay, so prevention works. The first is the vaccines. In the United States, we have 3 leading vaccines: Moderna, Pfizer, and J&J. As most of you probably know, the teachers are getting the J&J vaccine. That was the last one to get approval, and that is being administered primarily through the Rite Aid pharmacies. AstraZeneca is being administered internationally, but I just read something the other day that they're at about 70% efficacy, but I don't see or believe that they have tapped into the US market at this point. I don't know that they have FDA approval. Okay, the goal, this is Biden's goal that he put into effect in one of the very first days, was 150, it used to be 100, and then he upped it to 150 million COVID shots in the first 100 days. As of yesterday, there were 2,497,000 doses in the past 7 days. And you can see the daily average, which has gone down just a little bit. And I'm wondering if that's supply issues. I don't know. There's 37 days left to reach the goal, and there's 38 million doses necessary to reach the goal. So I think we'll get there. I think we'll get to the 150 million. It's an aggressive goal, but I think we'll get to that point. Now, what this means to all of you as employers who own your own businesses, but also as employers who face off to businesses and have clients that you work with that are businesses. The vaccine is huge. In terms of what do employers do? What do they have to do? What are they required to do? Do they have to have policies? Can they mandate it? Those types of things. And we'll go into a lot of that. But there are, what I've seen, 4 really overarching concerns that employees have expressed to me, to my clients. The first 2, personal decisions and fear, are, I call personal decisions those people that say, I'm an anti-vaxxer, don't care what it is, not getting vaccinated for it. I don't get the flu shot every year. I don't get any vaccines for whatever reason. That's their personal decision, but it's not rooted in any kind of medical medical decision, like they're allergic to something, or they have a disability that interacts with or interferes with their ability to get the vaccine. The second is fear. Those people that genuinely have a fear that it hasn't been tested long enough. I don't know what's going to happen in 20 years. What are the long-term side effects? Those type of people. And it's a legitimate concern. There's definitely people that have those fears. And then there's the two other fears, or concerns, which are religious concerns. I don't get it because of my religion. I don't get any vaccines with my religion. Or disability issues, which is what I mentioned before. Like, for whatever reason, I can't take, it has an ingredient that I can't take. It interferes with my disability medicine. Whatever the reason is, that's disability related. And I have spoken to those people. For those two bottom concerns, you as an employer, if you are mandating or requesting that your employees get the vaccine, or even if you're just having discussions and encouraging everyone to get the vaccine, and you have people that are in these bottom two categories, you must, as an employer, run through that ADA accommodation conversation, just like you would any other accommodation that an employee is seeking, like for a disability or a religious accommodation. You need to run through that. And there's a balancing act here, right? So as an employer, you have an OSHA requirement to keep your workplace safe, to keep your employees safe. So you have to balance that OSHA requirement, which is a requirement. It's not just guidance or a suggestion. You have this requirement against employees who are not getting the vaccine. So that's where many employers struggle with. They don't want to mandate it per se, but they also have to address issues where they have a select number of employees or one employee that isn't getting the vaccine for one reason or another. So as you look through putting together a policy, and I recommend as an employer, or if you work with employers, that you take a position, right? If you don't take a position, employees they don't know unless you tell them. And so have a policy one way or the other, whatever you decide. If you're doing a voluntary policy, right, have a written policy and then evaluate accommodations through an interactive process. If it's mandatory, same thing, same two requirements, but the CDC is now recommending that if you're mandating a policy, you should be paying employees for the time necessary to get the vaccine, as well as any side effects. But those are considerations that you need to really consider as part of whether or not you want to mandate a policy. So about a week ago, the CDC came out with some new guidance on vaccination policies, which we've been waiting for a long time. And they said that employers that are implementing any kind of policy should not charge the employee to have it, which I really haven't seen anybody being charged for it. I either see it being covered under insurance or offered as a no charge vaccine. Offer paid leave to get the vaccine, and we'll go into that in a little more detail further down in the presentation. Stagger the vaccinations. And so when I really thought about this, it made a lot of sense, because at first I was like, well, why would you want to stagger them? But here's why. If you have people, especially if you have shift people, but even if you just have people from 8 to 5, if you say, okay, we're going to have Rite Aid come in and everybody's going to get the vaccine today, like Rite Aid does that for the flu. The problem with that is if you have, 20 people in your office and 10 have side effects that last 1 to 2 days, you're going to have 10 people out. So think about it in terms of potential side effects that employees could have and where they need to take. And I have actually heard, although most people just say their arm is sore for a day or two, I think people that have had the vaccine, they can tell you if they've had side effects. They could put it in the chat, but that's what I hear. But I have heard people saying, 1 or 2 days, especially for the second shot, where they just didn't feel well and they took the day off. If you have a bigger office, have what they call, what the CDC is calling a vaccine champion, which is somebody higher in your organization, whether it's the president, the owner, the founder, the executive team, say, I got it. Don't have, if you're expecting your employees to get it, make sure your leadership is getting it. Consider offering it to your contractors. If you're in a position or in a workplace that has contractors, you should really consider making the same offering or encouragement to them as well. And again, it's that balance, right? So if you have a lot of contractors in your office, you have an OSHA obligation to keep your employees safe. So now you have contractors coming in that you're saying, well, they're not my employees, but you have an obligation toward your employees. So think about it in terms of keeping those, encouraging those contractors to get the vaccine as well, or incorporating them into any kind of plan that you have. Look at your accommodations if you need to. And if you have a mandatory policy, paying employees for the time. Now, the CDC also had come out with, initially, this guidance came out a little earlier, that said, we really discourage monetary. So paying people dollars to get the vaccine is really, really, really discouraged. And part of the problem with that is, what do you do for the people that can't get it or don't get it, right? So, and then I had a call from an employer that said, well, what if I pay them if they get a COVID test every week? And I looked at that employer and I was like, have you had a COVID test? It's awful. Like, it's traumatizing. I would not want to have a COVID test every week just to get a stupid $100 or whatever you're offering those people that are getting the vaccine, just because I can't get it. Like, that seems more oppressive to me, the person that can't get the vaccine. They recommend a day off, and they got highly criticized for this. They recommended a de minimis gift, like a water bottle. And, my thinking was, if I didn't want to get the vaccine, you telling me you're giving me a water bottle is not really an incentive for me to go, oh, now I really want to go get the vaccine. And although we haven't seen any guidance out there about this yet, what I'm looking for, and what I'm still looking for from the EEOC, is with those wellness initiatives that the EEOC has, how this may fall into like a wellness program, and if it does, how that can be part of that program for an employer. But I haven't seen that yet, so I'm still looking for it. And when it comes out, if you get my blog, I will do a blog on it. If not, I'll tell you about that later. So that's kind of where we are as of yesterday on vaccines, COVID, masks. Does anyone have, I don't see any questions in the chat, so I want to just give a minute to see if anybody has any questions on that, because we're going to transition now. We're going to have our breakout room. So I just wanted to make sure that before we do that, I answer any questions that anybody has. Okay, so.
I'm sorry, I had a quick question.
Yes.
And maybe I missed it there, but is it legal to mandatory to require the vaccine?
It is legal to require the vaccine. You absolutely can require it.
And if people refuse to take it, can you fire them?
If they don't have an ADA accommodating disability or religious exemption that you have to accommodate, you can fire them. It's very similar to, and I've actually had to go through this with an employer. The employee that said, I don't want to come back, I'm afraid. I don't have a person at home that's high risk, or even if I do, like, just because your fear alone is not enough to warrant, an accommodation like an ADA type of accommodation. Now, I say that with caution to say, I would consider that wholeheartedly, to say, think about the ramifications or ripple effect of that, because we are living in a quite litigious society. So, but yes, legally, you can fire them for that.
Thank you.
what are
Welcome.
some of the accommodations, Tina, that you could do?
Well, if that person is teleworking, you can have them continue to telework. That would probably be the best one. I have worked with one employer who put that person, like, so the rest of the office worked 8 to 4, and that person came in and worked 4 to 8 on Saturdays. Like, so changing that person's shift, and actually just making them work when they're not exposed to other people. It's challenging. It's really challenging, but there are definitely ways to make it maneuverable. And I do see a question. OSHA, mostly guidelines. Yes, mostly guidelines. The requirement to keep your employees safe is required, and OSHA just put out something which I have a slide on later. But they just did put out something that they are starting to ramp up doing investigations and following up on complaints about workplaces that are not being safe with their COVID policies. And like, either they don't have a policy, or they don't, their employee, like, they feel that their employees are not safe. Like, either they got a complaint, or they have some reason to want to investigate because of a COVID safety issue. Another question, religious exemptions. How do you question or validate this? So you validate it just like you would any other ADA accommodation that you would do. You would say, is there, I wouldn't, it's always a challenging conversation, because you don't want to feed them the information so they can say, oh yes, I absolutely have a religious accommodation. But you kind of want to let them tell you what is the reason. And as an employer, you have a right to ask that. And through a pandemic, you have more of a right to ask personal questions and medical questions than you would under ordinary circumstances. So you can ask them, is there a medical or other reason why you are refusing to have the vaccine? And let them expand on that, and keep pulling out of them without feeding them the legitimate reasons that you have to accommodate as an employer. Any other questions?
Okay, well, we're going to go into the breakout rooms now. Before we do, though, I've been told if I take a picture, I have to ask. So this is Zoom etiquette, I understand. So everyone say hi, smile. This will be posted on LinkedIn and on the Beacon site. So if you want to have your face there, that's great. I love it, Morris. All right, everybody. Tell me that shot may have been blurry. We'll see what happens. Okay, I'm not a photographer, obviously. All right, Zoe, can you do your magic? So
Yes.
For 10 minutes.
Do I have to do stop share?
You don't have to if you don't want to. 10 minutes, Amy, 4 people in each room. Any guidance on what they should discuss in there?
Yes, so introduce yourself. If you don't, there are a couple of new people here. Tell them how great Beacon is and they should join. And then also talk about what Tina said, which is, how is this going to affect your business yourself or your clients' businesses? How can we utilize this information?
You're on mute.
Is everyone back now?
Yep, everyone's back.
Okay, great. Did anyone want to share? You don't have to, but if anybody wants to share, welcome back.
This is Frank. I'll ask a question. I meant to ask it before the breakout, but Tina, based on your kind of discussions with employers, is there kind of an estimate of where, like percentage-wise, where most employers are in the, like, I'll say the office worker type of employers in the, we have a plan to come back, we're not talking about it just yet, or where they kind of stand at this point?
Well, it's interesting. We talked about that in our breakout, and I said that a year ago, I actually gave a talk on when we were in the red, green, yellow phases and the green people were getting ready to come back, I did a presentation for an organization on reopening the office. And, I feel like, and then I just got asked to do, and I'm doing one in May on that very same topic. And I was like, wow, it's like Groundhog's Day. It was a year ago. But I'm actually hearing a lot in the past week or two about businesses like in a more office setting, starting to look at bringing people back. And I guess because I had done that presentation a year ago, I had just taken the assumption that more and more people were coming back. But I think I'm hearing discussions now, I think with the vaccine and people getting vaccinated, maybe, into the summer months when, you can open windows and there is more outdoor activity, that people are starting to talk in the office settings about coming back, but doing it more in like staggered shifts and I know, some offices have completely redesigned, and I'll talk about this at the near end of the presentation in terms of employer policies, but what a lot of offices have reconfigured to do is to do much like manufacturing did very early on, like shifts, like these people are on team A, they come in on week 1, these people are on team B and they come in on week 2, and then redesigning some office space to, just have, this desk, you can come in and use this desk this day, but it's scheduled. So it's not like, hey, we're open and everyone come back to the office. It's done either in like a shift type of situation, or just gone, I think, are the days where everybody got their own office and that's everybody's going back to their office. There's much more like a co-working space that I'm starting to see, with cleaning every night in between.
Tina, and I asked Amy if it was okay to mention this, but April 16th, another Beacon group, the Human Resources group, has a presentation. 2 HR folks who are in seat are going to talk about, one of them's been back since June, and so kind of their lessons learned. How did they do it? What did they do? And the other one is not back yet, and to hear what they're thinking. So from an inside the company perspective, I think gives a different perspective than this.
Right.
But this has been great. So April 16th, shameless plug, 8 to 9:30. Sign up now. Beacon for life. Thank you. Thanks, Amy.
Shameless plugs are always good. They're not shameless. Okay, any other questions? Any other thoughts from, your discussions? Okay, I'm going to move on. We have lots to get to. So we're going to start with new president, new policies, new rules. Right now, we will have for the next 4 years a Democratic president and a Democratic Congress. And I think it's really important to have this discussion, and I do it every time I give this presentation. And I don't do it for political reasons. Please don't mistake what I'm saying. This is not a political conversation. I don't care what your political ideologies are. This is more a viewpoint of what you as an employer need to know, and what you as an employer who works with other clients and businesses need to understand. And that is, when you have a Republican president, Republican philosophies and ideologies are very pro-employer. So regardless of your viewpoints of certain political leaders on either side of the fence, President Trump, when you look at it, was pro-business, pro-employer. Everything was pro-employer. And when President Trump came into office, agencies like the Department of Labor and the National Labor Relations Board were completely slashed in funding. Like, their budgets were completely cut. And now you have a president who is Democratic. Democratic philosophy is pro-employee. So, and you also have now a Congress that's synonymous to that. What that means is that agencies like the Department of Labor and the National Labor Relations Board are typically employee protection agencies. And so those agencies will grow. And if you can recall back beyond the 4 years under the Obama years, those agencies became very large and very powerful. And there were a lot of wage and hour and independent contractor focused type of claims, misclassified employees. You remember in 2016, I'm sure Mike Davis remembers because I was giving a speech the night when that injunction went into place with another organization that he's involved in, that the overtime regulations were supposed to go into effect, and they were going to raise the threshold at which employers need to pay overtime. So those are the types of policies that are democratic pro-employee policies. And so what I think that will mean, and we'll talk about this, is that, you know, those gig workers and those independent contractors, which became very, very popular and very strong and building those ranks of the independent contractor, I think you're going to see more of a shift toward a focus on employees. And that's just by way of democratic philosophies that are now leading this country. So we're going to talk about that, but I say that to keep that in mind in terms of when we go through some of these new policies, that is the philosophical approach behind them. So we're going to talk about the American Rescue Plan. We're going to talk about some of the new executive orders very briefly. We have a bunch of OSHA guidance to go through. We're going to talk about those independent contractors. We're going to talk about the FLSA exemption status, and we're going to talk about the growth in agency power. So first, the American Rescue Plan, huge piece of litigation, lots of money, but what it means from the employment law perspective, there's a couple things. An increase in $300 on top of the unemployment compensation benefits. How do you get your employees back when you have employees that say, I'm not coming back because I'm making more on unemployment than I'm making at work? And so here's how you get them back. If they're collecting unemployment and you call them back to work, they are no longer eligible for unemployment. So they can say to you, I'm not coming back, if they're so bold, because sometimes they won't even say that. But if you call them back and they decline for whatever reason, and we all know the reason in the back of our head, you can and should, as an employer and as a business that works with employers, notify unemployment that they are no longer eligible for unemployment compensation because they have a job available to them. And if you have available work, you are no longer eligible for unemployment. So that is how we need to stop the vicious cycle of people on unemployment. And as employers, I say to you, you have a duty to do this because there's a lot of people on unemployment that have no incentive to get off of unemployment. But if they know that they're not going to get that check anymore, that's their incentive. So whether you tell them that or not, I'll leave that to you, but you should report it to unemployment. Okay. The Family First Coronavirus Relief Act, which was the first act that came out, which was the Paid Sick Leave Act, which I've spoken to many of you about, is continued, but now it's voluntary. It was voluntary through the first quarter, and under this new plan, it is voluntary till the end of the third quarter. The next point, use FFCRA to get vaccinated, how to use this to your benefit. So many employers said to me, I'm done with it, I paid it, I'm getting my tax credit, but it's a huge inconvenience for whatever reason, and I'm done with it. But now you have, and you don't have to do it anymore, even though under this new plan, the bank, so if somebody used all 80 hours of this paid sick leave, they get a new bank April 1st. So they get another 80 hours. And if you're in Philadelphia, by the way, a lot of this goes out the window because there was revisions to the Philadelphia sick leave law. I'll talk about that in a minute. But They get a new bank of 80 hours at beginning 4/1. So now you have multiple competing interests as an employer. You have an employee or a set of employees that need to get vaccinated. You have an OSHA guidance or suggestion that says you should be paying them for this time. So then you tell your employee, I really want you to get the shot, or I'm mandating you to get the shot. I'll give you paid leave to get it. You have to use your PTO. How do you think that's going to go over? Like a big lead balloon. Employees do not want to use their paid sick leave, particularly if they had to do it last year with their vacation time because they're sick with COVID, and now because they have to get a vaccine. But under this new plan, you can use FFCRA leave to get them vaccinated and for any subsequent side effects. So now you look like the hero. Get the leave. I mean, get the vaccine. Take a day off because you don't feel well. We'll pay you. Tag it as FFCRA leave, and then you, the employer, I mean, granted, the employee's still out of work. But that's going to happen anyway. If you tag it as FFCRA leave, you get the tax credit. It's a dollar for dollar credit on the FFCRA. So you get the tax credit if you tag it as FFCRA leave, as opposed to PTO leave, which they don't want to take and is a huge employee dissatisfier. And you're encouraging them to get the vaccine. So that's the benefit. That's the way to finagle this, to get you get the benefit, they get the benefit. Mike Davis, I believe that reporting employees who won't come back to work is required by PA law effective last April. It is, and there was a form, and thank you, Beth, for putting that form in there. I was going to say I can email the form, but thank you, Beth, for putting that form in the chat box. So as an employers, you have that duty to report these people, and there is a form to do that. And Beth just put that in the chat for all of you. So thanks, Beth. For always having my back with these little tidbits. So that's on the FFCRA. Now, I mentioned Philadelphia. So for those of you that are employers in Philadelphia or work with employers in Philadelphia, Philly has this paid sick leave law. 5 days accrued every year can roll over a maximum of 40 hours that can be used in any given year. Very quietly in September, the legislator in Philly amended that law and added 2 new provisions to it, mostly relating to the healthcare industry for those workers that were exempted from the FFCRA. So if you were a healthcare worker and you were exempt from paying FFCRA leave to your workers, in Philly, they amended their sick leave law and required you to provide paid sick leave under the Philly sick leave law, similar to and more generous than the FFCRA law. And they are enforcing it if there's a complaint, because I have had to answer one of those as well. And some of that expired December 31st, but I believe there's portions of it that did not expire. So if you need more information on that, I have a whole article on that. So reach out to me and I'm happy to send you the article that I have summarizing that. And then very quietly, I also read just like a week or 2 ago that, and I don't know, I'm not really certain. I think it is part of the rescue plan, but that there's free COBRA. Now, I'm not a benefits person, so I don't have a whole lot of information on this, but it is free for 6 months, COBRA, offered to employees who separate from their employer. And that includes mini COBRA, and it's done through the healthcare plan. And your benefits person has way more information about the logistics of how this works. And thank you, Beth. It must be an involuntary separation. That they get the free COBRA. Here's the bad part about it. It's 6 months. So let's say you let somebody go April 1st. They get free COBRA for 6 months. Then they have to get COBRA. They have to then pay for COBRA, because at the end of that 6 months, it doesn't qualify as a changing life event to allow them to go on the marketplace. If they're involuntarily separated today, let's say effective April 1, just to make it easy, they have two options. They can get COBRA or they can go on the marketplace. And so we all know COBRA is astronomically expensive. And let's say they find something on the marketplace that is significantly cheaper for them than paying COBRA. It might actually be more cost effective for them to pay to just pay on the open marketplace, because they're not allowed to go into the open marketplace until January 1. So they have to cover the gap between the 6 months, which isn't that going to be that much at this point because it's only 2 months, I think, and COBRA. So, or 4 months. I can't do math. Anyway, so I just tell you that to say.
Thing on that though, Tina, which is also the fact that with this law, the very soon, they haven't implemented it yet, but a lot of people, they're increasing the amount of income that a person can have to qualify and get the subsidies, and they're increasing some of those subsidies for a lot of people as well. So they've kind of done both those things at the same time to make the marketplace a little bit more
appealing.
Yeah. So they haven't come out with it. I think it's like 4-1. And then each of the states, like Pennsylvania, has a penny program, which is, so they haven't come out with how they're doing it, but all of that is still happening too.
Yeah, it's really, there's a lot happening in this little arena. And the question is, what about people that are on COBRA before this legislation? Jeffrey, my understanding is that they still get the 6 months. Even if they're already paying, they get the 6 months free, but then they have to go back to paying, I believe. What guidance do you have for employers looking to sever an employee during this COBRA subsidy time as well? That's a great question, Beth. What I have been doing is if I have an employer that we're doing a severance agreement for, I either tell the employer to speak to their benefits person, or I get the benefits person's phone number. I haven't had the issue since this new COBRA law came up. I only spoke to somebody that I know in the benefits world. But that's what I've done in the past, even with issues with COBRA, is to say, how do you speak to them, or let me speak to them, so that we make sure that we're addressing it in a severance agreement. Because I got to tell you, with employee benefits, it's been all over the map. I've had employers that have said, okay, we're going to pay your first X months of COBRA. And then I've had employers that have said, we're going to keep you on the rolls as an employee, pay your X months of insurance, and then we'll put you on COBRA. So they actually delay the termination date, even though the employee's terminated, until that, whatever that X period is, like 4 months. And then the employee gets the full bank of COBRA. So it's more beneficial in some ways for the employee that way, if they want to do COBRA, because it's so astronomically expensive. But I've seen it all over the map with how people administer that COBRA benefit to begin with. But yeah, so that's what I do. I always work collaboratively with their benefits person, or have them work with them. Yes, I've also seen that, Beth. The comment is, I've also seen employers pay a lump sum out toward COBRA for a finite time. I've seen that too. And I've seen where the employer will has to pay the employee, and then the employee makes the COBRA payment. So they have to gross up the COBRA sum, because it's seen as wages. They have to gross up that COBRA payment amount, and then they pay the employee, and then the employee pays COBRA. It's really all over the map with COBRA in terms of severance agreements and how that works. Okay, so let's move on. Executive orders. So immediately when Biden came into office, there were a couple executive orders that were relevant to employers. The one most significant, which dealt mostly with government contracting, was the repeal on ban on racial bias training. but also the expanding the discrimination to include gender identity protection, repealing the ban on transgender serving in the military. The reason that is important to you all as business owners and people that work with business owners is I think you are going to see in the next 4 years significant advancements in protections against the transgender community, whatever that broad scope of individuals is, including gender identity, gender questioning, that entire population of individuals. You're going to see a broadening of rights and protections for those people. And so to the extent that you're an employer that either has any of those individuals working for you or is hiring and confronts or meets any of those individuals during the hiring process, though those protections continue to evolve and develop. And so, and I think you're going to continue to see that. And so I raise that just as a keep this on the radar, because you will start to see protections where you didn't see them before. The President's Council of Advisors on Science and Technology, I think that's a great advancement, and I think you're going to see a lot more decision making based on science and technology than we saw over the last 4 years. And I just put a flag, like with the transgender, I put a flag on the last one, like what are we going to see in terms of the ACA? I think you will see some significant changes coming down the pike, but I haven't seen anything yet other than the COBRA. Okay, so OSHA, let's move to OSHA. I've never had so much focus on OSHA in my practice as I have in the past year. January 29th, OSHA came out with a COVID prevention policy with some handy dandy steps on what employers need to do, particularly if they're reopening their workspace, on OSHA guidance. And this is not new to PA. The PA Department of Health had put out significant guidance. Again, these are guidance. They're not regulations, they're not requirements. But Dr. Levine and the PA Department of Health put out similar guidance many, many months ago, probably in June, on reopening the workplace and requirements under PA. So much of this is not new. It's just now at the federal level. They're saying assign a workplace coordinator. In PA, that person is called a pandemic safety officer, and that was part of the PA guidance. Usually that is your HR person for companies that are small or don't have an HR person. I work with the O'Connor Group a lot. I know they have pandemic safety officers, but that person is just there to implement your policies and all of the issues that you may have with respect to reopening the workplace. So identify where and how workers may be exposed, identify a combination of measures to limit the spread. What we say is look at every single area in your business. Look at your high touch areas, look at your kitchen, look at your coffee maker, look at your microwave. Think about, for those people that are not back in their office, think about where your employees congregate. Think about if you are on a shared floor, shared bathrooms. Think about the keys that, like, if you're particularly if you're in Philly, most of those office buildings have a bathroom on each floor, and there's a key at the reception desk that everybody picks up and uses. Think about things like that, high touch areas, things that are shared. How do you? And it's just as easy as just putting a policy in place and communicating that so that everybody's on a level playing field. Everybody understands what the expectations are and what will be provided to them. Do they have to wear masks? Are there going to be is there plexiglass in between desks? Like, are you moving desks around? All of those things need to be addressed. Communicate it to your team, educate and train. Keep sick employees at home, allow teleworking when necessary or as accommodations. And I think what you're going to find is that you're going to have people that don't want to come back. You're going to have people that can work as easily at home. And we'll go through some of the ramifications of that as well. but I know Beth and I have had multiple conversations about this. And, one of the important things about this is make your employees part of this process. It's so important to do that. They have great ideas. It shouldn't be you as the owner or founder dictating this. Is there a standard for COVID cleanliness? Does a company have any certifications to have any cleaning to COVID? I have seen in different places in terms of COVID cleanliness certifications. I would say it's worth a call to OSHA to say, do you have certain standards? Are there certain things that you're recommending, certain cleaning products, that kind of thing? I don't know the answer to that because I'm not really a big safety, like that's not my area, but I would definitely say call OSHA and ask them those questions. They're really super helpful there.
Yeah, Christina, my experience when I had distribution centers that I was trying to protect was we were going through crazy amounts of cleaning almost hourly on surfaces and whatnot, only to then find out that it's the airborne that's the issue, really not the surface. So is it really OSHA that sets that standard, or the CDC, or who can really help companies understand how much they should be investing in the surface versus the airborne?
I would definitely start with OSHA, but Beth says that the CDC has standards and the PA Department of Health and Safety also has standards for buildings.
I
Thank
know
you.
a couple of companies, Jeff, that not only they can go in and do the airborne, and they literally cleanse the air in a very short time period. They also kill all the mice and other insects that might be in it because they literally suck the air out. Everyone has to not be there for a period of time. But I know that's a process that some companies are doing, and within residential as well as in like distribution center or office buildings. We can talk offline if you're interested in hearing about it.
Amy, I have experience with that. I actually used a company, but that was when we had an actual COVID outbreak and we had to basically remediate the entire facility. I'm talking more about the day-to-day issues with, like handing off keys and things of that nature. But thank you.
Well, and the other thing that I have recommended is that particularly if you're in the city, like or even if you're in the suburbs, what are your obligations versus those of the landlord if you're in like an office building where you're renting space? And so I encourage you to look at your leases and have those conversations with your landlord to the extent that you are renting space. I did hear a lot about companies that were either renovating their HVAC systems or putting in like HEPA filters and things like that to circulate that air and clean that air. So I have seen and heard of employers taking those types of precautions. But yeah, I would say the agencies so far that I've had experience with in terms of calling OSHA and calling the Department of Health, the only agency I got to tell you honestly that I have absolutely zero luck with is unemployment. You can't get through to them at all. But these other agencies have been pretty great about answering questions and being available. So this guidance all came out on the 29th, and then just this past week, about a week ago, OSHA issued additional guidance on enforcement where they said that they were going to prioritize inspections and perform on-site inspections to the extent that they are able to do so. They're going to address violations of OSHA standards and investigate referrals and complaints received. Now, that being said, I have seen nothing about, and Beth, you could put in the chat if you have, about penalties, like dollar penalties associated with these, but I have responded to complaints, written complaints that were sent to the employer. But I haven't seen anything that says if you don't comply, it's $100 a day or something along those lines. So, that remains to be seen, but they did publish some enforcement that they were going to start enforcing. And I remember very early on, they were criticized for not, like, there was no enforcement mechanism and they hadn't been taking any action to respond. So that's new. Okay, independent contractors and joint employers. This is very much evolving, and I think will continue to evolve over the next couple months. As I mentioned, there was through the last 4 years, there has been, as I'm sure you are all aware, such a rise in independent contractors, the use of independent contractors by business owners, the gig economy, and I'm sure you've seen the articles or heard on the news about the Uber drivers and the Lyft drivers and those types of lawsuits about whether those were truly independent or whether they were employees. And the argument is, you know, as a state or a regulating body, they want those people to be employees. They get more protections, but from a state's perspective, they get taxes. They get money for those people, and they're covered under workers' comp. They're covered on unemployment. All of those benefits that come with being an employee that makes having an employee so costly aren't part of the independent contractor scheme. And where does that blow up? Where did that blow up on March 16th, when all the independent contractors who were solopreneurs or small shops, particularly solopreneurs, lost all their business, particularly the marketing people and the PR people and the coaches. They were all independent contractors and they got cut from the clients they were working with, and they had no remedy. They didn't pay into unemployment, so they couldn't collect, and they had no source of income. And if they were PS, if they got COVID, they couldn't even make a workers' comp claim. Some of those are covered and some of those aren't. That's still evolving too, but couldn't even make a workers' comp claim because they didn't have that either. So there was a new bucket of, and I know Amy and I have spoken ad nauseum about this, about independent contractors who were finally able to collect unemployment, as horrific as a process as that was. But that's why there's such a push for states to make these people employees. And that's why a democratic philosophy is they're employees. They get all these benefits. We treat them well. But as a business owner, you like to have them as independent contractors because it's cheaper that way. So that's the push and pull back and forth. So it will be interesting to see, kind of particularly with the gig economy and those gig workers, what will happen to them, and how that will evolve. Because what I'm seeing now is, as businesses are opening back up and they're very trepidatious about their cash flow and how much they have and how long they're going to survive and how much PPP funds they have, that they're bringing on independent contractors because, one, it's cheaper. 2, it's an easier way to cut them loose if things don't work out. And 3, they don't know if their business is going to last more than 3 or 4 months. So let's bring on an independent contractor to be our CFO or our marketing person or our HRO or our worker, and then we'll see where it goes. And that's not the way the law was designed to work, but that's the way businesses are handling it. So very early in January, before President Trump left office, there was a new independent contractor test that was put out, and they were asking for comments on that, and that has been withdrawn. So we're back to the old tests, which is the IRS test and the Fair Labor Standards Act test. But we'll see. The Department of Labor is, there's new heads and there's new leadership coming in, and I'm sure you're going to see more funding toward that department and that agency. And so that remains to be seen. Do you see the definition of independent contractors being expanded to include more independent professionals? Newell, I think that's a great question. And I think a year ago, I would have said yes. Now that I think there's a huge collision between the democratic philosophy and the present world we live in, which is more independent contractors, more people working in that gig type of space, and an employer or a business owner having less employees and bringing on independent contractors to do that work, particularly even in roles like a CFO. Like, I don't need a CFO 5 days a week and I can't afford it. So I want one of those temp CFOs that comes in 1 day a week, and that's all I need. And that's what businesses are doing, and that's what I'm seeing. And so I think I could all day long argue that a CFO should be an employee. They're an integral part of the company. You control them. They're controlling your finances. Like, they check a lot of the boxes on that test. But I could also argue that, I don't need them every day, and they can work from their home, and like that they check boxes on the other side too. So I think that it's going to be a really interesting development of the law.
A couple of things. I want to expand on that a little bit, because this group is a lot of independent contractors. So I want to make sure that people have the time to do a couple of things. One thing also, one of the areas that that Tina and I have worked on together also is the PPP. And for those of you who know, just March, I'm going to say 11th, February, it just happened where they decided, oh yeah, by the way, here's the new form, and they revised the PPP for those who are independent contractors with a 1040 Schedule C. So they literally revised that whole process again to say, hey, we left you out of the original. We didn't let you take as much money as the others. You don't pay yourself. We're going to consider the payroll. And they literally changed the definition of that payroll process. So now it's based on your revenue numbers, not the net income on that Schedule C. So it really changed how much you could have. Now, similar to the people who were in COBRA, if you got less before, you couldn't go back and get it again. But if you have not drawn on schedule on round 1 or round 2, it is still open until Wednesday. I think that's the 31st. Wednesday is the last day, but there's still on the PPP, there is discussion about extending that for another 2 months. It's passed the House. It has not passed the Senate yet, but it is in the works. So pay attention to that. Again, a lot of independent contractors might be eligible for that now, so pay attention. Tina, can you go through just some of the specifics in terms of what determines an independent contractor versus an employee?
Sure. So having gone through, short of an IRS audit, I don't know what's more painful, a Department of Labor audit or an IRS audit. But I can tell you that there's a whole, under the IRS test, there's 20 factors. Under the Department of Labor, which is the Fair Labor Standards Act, that's the law, the federal law, there's 8. Could I get all 8 off the top of my head? Probably not, but I can tell you that the ones that the Department of Labor really focuses on, number 1, control. How much control does the business owner have over you, the independent contractor? Do they control when you work, how you work, where you work, the type of work you do? Do they review your work? There's a lot that goes into that control, but that's kind of what they look at. The other thing they look at, the other big one, is, are they integral to your business? So this is where home healthcare gets into trouble. This is where like smaller places like nail salons get into trouble. That's what your business is. So if you have a bakery, I always say, if you have a bakery and your baker's an independent contractor, that's what your business is. Like, that person is integral to what you do, the product you make, or the product or the service you provide. So to the extent that you have individuals that are integral to what you do or provide or create, those people shouldn't be independent. The other thing that people look at is the ability for profit and loss. So think about an independent contractor that gets paid by the project or gets paid a lump sum for a certain amount of time, whether they get paid some up front and some at the back end, or they get paid a certain amount for a certain amount of months. Or if it's a service, like I always say, like a painter, like if you hire a painter to paint your office, that person is not integral to your accounting business. Let's just say, because I'm looking at Amy, that person is not integral to your accounting business. So, okay, they check that box. Now you say to them, or they say to you, it's going to cost you $1,000 for me to paint this room. And whether they do that in a day or in a week depends on their schedule and when they want to work, because you don't control that. But also, if they do it in a day and they can do 4 other jobs that week, then they've made more profit. If it takes them a whole week to do it, then they've made less profit. So their capacity or ability to control their profit and loss is a significant factor. Now, think about it in terms of that home health aide or that nail salon or fill in the blank. Those hourly workers, they have zero control over their profit and loss. You're paying them an hourly salary. And what the Department of Labor looks at in those circumstances is you're paying them an hourly salary, an hourly rate. They have zero control over profit and loss, because it doesn't matter how hard or how quick they work, they're going to get paid the same amount of money. The only person that benefits in those circumstances is the employer, because you're going to pay them straight time because they're an independent contractor. And so if they work 60 hours a week, they're going to get paid for 60 hours as opposed to time and a half for 20 of those hours. And that's another factor, is how independent are they, right? So if they are a home healthcare worker, and I say that because I have a number of these and I've had these issues over the years. If they're a home healthcare worker and they're working for you for the past 10 years and they're working 60 to 70 hours a week, they're not independent at all. They rely on you 150% for their sole livelihood. So those are kind of the really key factor. There's other factors like, do they use their own tools? And by tools, it could be anything. It could be their computer, it could be their drafting table, it could be their laptop, it could be their phone. Do they use their own tools? Do they have their own uniform or insignia or shirt or colors or business cards? Like, what makes them look independent of you? And do they have the ability to hire or fire? So I'm going to pick on Frank because I see him now in my viewer. So if Frank says, I'm never going to get this done in a week, I'm going to bring on somebody that's going to help me, like one of my people, and they're going to help me get through this. Well, Frank has the ability to do that because he's independent. And so the ability to hire or fire your own staff and to bring on people to assist you with the work, which depends on the role that you're hired to do. That doesn't always work out. It's not dispositive, but it is one of the factors that the Department of Labor would look at. So those are kind of the major factors that they look at. And I always say, take it from the example of that painter example. Like, a painter would never be integral to the business of a CPA. And they work on their own time. If the painter said to Amy, well, I can't come till next week, Amy's gonna be like, okay. Like, she's no control over when that painter is gonna work. So that's kind of how you have to look at that analysis. If you give them a start date and that's when they start and you expect them to work, and you give them an office or a location where they have to work, even more compelling that they're an employee. But those are the factors that the Department of Labor looks at. Okay. Let's see, the joint employer rule. This has been repealed, so we'll see what happens with this. Again, look at this from the perspective of philosophies. The initial rule was put into place. There was a lawsuit, I believe it was McDonald's, one of the leading cases, where an employee was injured and she sued McDonald's, the franchisee. And then she sued the parent company and said the parent company is dictating the work of the franchisee, so I'm going to sue them both. And obviously, as an employee, you want to get to this company because this company has a deep pockets. So it was control. They were looking at control, And they, again, pro-employee, because this was under the Obama administration, they found, yes, there was a joint employer rule. Then that changed in, I think, 19 under the Trump administration, that made it harder to find that joint relationship because they're pro-business. So they want to protect the business owner. And the rule that was put into place in 2019 has now been repealed. So it remains to be seen whether that old connecting rule will come back into play. And I can tell you, I've actually seen this with one of my own clients. They owned a restaurant and a dessert shop, 2 different LLCs, 2 different companies, same ownership at the top. The employee would work at the restaurant. Let's say the employee worked at the restaurant 30 hours a week. Okay. Then the employee would work at the dessert shop 25 hours a week. No overtime. So the big question is that employee entitled to overtime? Now you're in a Democratic presidency, and is that joint employer rule going to become strengthened again? Because what the Department of Labor will look at is same control at the top. And so now you have 2 different LLCs, same ownership. Should that employee get overtime once they hit 40 hours? So for that other 15 hours, should they be paid time and a half? We'll see what happens. Stay tuned. Again, I raise it as a flag. These are all kind of issues that are going to evolve as the presidency kind of continues. Okay. But important for all of you as you work, as your independent contractors, and as you work with clients on a variety of issues. This is another big change. So this is the change that I referenced earlier, where I was going to speak for an organization that Mike Davis was involved in. And the night that I was speaking for an hour and a half on the increase in the overtime thresholds, the nationwide injunction came into place. So the current threshold is a 2-pronged test under the Fair Labor Standards Act. It's $35,568 or $684 a week. So if an employee meets certain duties and makes over that amount, no, hold on. I always have to think in my head. Under that, over that amount, they must be paid overtime. Under that amount, they must be paid overtime. And so when that nationwide injunction went in on the federal level, employers went, because the state levels were so low, okay, we don't have to pay them overtime if they're making this certain amount. But what PA did, again, I didn't see a whole lot of press on this, but what PA did was effective to October 3rd of this year, 2021, they raised that. And they'll raise it again next October, so that if you have an employee that's making now under 40,000, they have to be paid overtime for hours over 40. So they need to be converted to hourly and paid overtime. So if you have that assistant manager who's opening and closing a store, or yes, PA also requires the duties test. So yes, the duties test has not gone away. So they have to comply with the duties test, but you know, there are so many people that fall in that bucket of, okay, I bump them over the 35 and they're an assistant manager, or they're a paralegal, or they're an office manager, and they're over the 35. So I don't have to pay them overtime. Well, so come October 1st, that threshold is going to be 40. So what that means to a business owner is if they're making under 40, you either have to convert them to hourly and pay them overtime, or you need to bump them over the 40. And that'll change again next year. And I think what you will see is you will see that increase at the federal level as well. Okay, let's see. Okay, pitfalls with employees teleworking in COVID. I continue to put this slide up there. because I think with people working at home, it's so hard to track. Everybody had transformed their entire workforce to work at home, including their hourly workers. And so, but the challenge became, how do you capture the hourly workers and how many hours they're working if they're working at home? And you have to be really, 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 really careful, because we're in a society where anybody can log on at any amount at any time and work or answer emails or respond to that text message. I mean, I do more on text messages than I ever did, and it's challenging. It's challenging to work that way because you don't have that record, you don't have that email, you don't have that. But even still, like if it takes 5 minutes, if that's an hourly employee, they need to be paid for that. Or you need to figure out a way to not let them work when they're not supposed to work. Because what happens is, if they're working 10 minutes here and answering a voicemail here, or they're getting a call from their boss here, that all adds up. And then does that hourly employee, particularly if they're really close, fall like a receptionist who's answering phones at home because the phone line has been now, forwarded to their house, or to a certain cell phone? Are they going to fall below minimum wage because they're working all these extra hours that they're not getting paid for, essentially? And that's what the Department of Labor is good. That's where you're going to see the focus, I think, on things like this. And also overtime. Like, are they getting paid overtime if they're working over 40 hours? And if they're entitled to meal breaks, are they taking them, or are they just continuing to work? Because I know people that are working, like they're working. They feel like they never stop working, or they're not working at all. I feel like there's not a whole lot in between. You're either slammed or you're eating bonbons on the couch. Like, I don't see a whole lot in between. And how are you reporting and tracking that time? And by the way, there's a lot of great apps that have come out for that. Other issues with agency changes. I think you're going to see more of a push for unions. I'm actually answering a union issue right now for a contractor, but I think you're going to see more interest in companies trying to unionize. Unions are pro-employee. That's going to get attention. That's going to be supported. Whereas under the prior 4 years, that was not supported. Social media monitoring is another big thing. 4 years ago, when the National Labor Relations Board was very well funded, they started focusing on this concept of social media and monitoring social media, and employers that terminated employees for posts on social media. And I could do a whole seminar on that, but the takeaway of that is, have a good social media policy, enforce it uniformly, and employees do not have a First Amendment right to a job. So you can fire them for posts that they put on social media, except if they're speaking about the terms and conditions of their employment. If they're talking about the fact that they're miserable because they have to work during COVID, or they have to work all these extra hours, that's terms and conditions of employment. And you have to be really careful if you want to fire them, even if they say horrific things about you. So that's where the balance comes in. And I think we've already talked about this misclassification of wage and hour, independent contractor versus employee, and exempt versus non-exempt. Okay, just really quick, because I promised I'd give you COVID updates. I should probably move this up. This just came out. The PA state gathering laws, that they increase the capacity for indoor and outdoor. Okay, so what employers should do? There's leadership above all, communication. But policies, I can't tell you how many handbooks I'm looking at right now, and that my firm is looking at. Update your handbooks. Have your employers update their handbooks. Aside from all the new laws that went into play and are continuing to go into play, you really need to make sure that you have some of these policies, teleworking policies. We talked about like Zoom etiquette policies, proper attire on Zoom policies. There's so many new policies that have been triggered as a result of the new way of operating. as well as if you're reopening your workplace, all of the reopen policies, the pandemic policy, the COVID policy, the safe workplace policy. Make sure that you have policies and communicate to your employees. Other policies to review, reimbursement policies. Like if you have all your people working at home now and they have printers, are you paying for their toner? Are you paying for their paper? Like they're working for you. You need to think about, particularly if you have people that moving forward are going to remain at home. I'm not saying you have to do any of this, but this is stuff that you would be paying for if they were in your office. If they're using their cell phone now and they're not in the office using an office phone, like, are you paying for that? Are you paying for internet? Like, I realize these are additional costs to an employer, but this is super significant. Vacation policies, leave policy, paid sick leave policies. These are all things that an employer really needs to look at in terms of as they reopen their workplace, but also as they have people working at home. And right along with that, in terms of just looking at the telecommuting people, what equipment do they have? When they are in an office, they are in an ergonomically designed workspace. Not so at home. People are working on their couches, people are working on, fold out tables where, wherever they could work, on the dining room table, wherever they could work. Is it ergonomically a good position for them, a good situation for them? The expenses to continue to work at home, like that just came up the other day, like the toner and the paper came up with a client the other day. The record keeping, the meal reporting, we already talked about some of this, but the big one that nobody's really talking about is the workers' comp. And if you have people that are continuing to work at home and moving forward will continue to work at home, are they covered under your workers' comp? If I get up from my desk and trip over my computer cord and break my leg, am I covered? Am I covered under a workers' comp policy? I don't know. You definitely should be on the phone with your, like at the end of this call your workers' comp carrier, have your employers call their workers' comp carrier, whoever you're working with. That's super significant because these are big issues and you want to make sure that these employees, especially moving forward, are covered. And lastly, huge pitch, huge implications to mental health, huge. Employees, we are going to see huge upticks in mental health issues and concerns. As a business owner and as a consultant working with business owners, you need to make sure these businesses are aware of this and offer resources. There's a lot of people out there that are really suffering and anxiety and stress. And the American Foundation for Suicide Prevention, which I'm really involved with, has a number of resources for businesses and employers. There's a lot out there. There's a lot out there that's free. There's a lot of people that are really suffering. So make sure that you're addressing your employers or your employees' mental health needs. And lastly, this is the exposure from a litigation perspective. There's like minimize your risk. Like I said from the very beginning, I work on employer compliance. And so we try to minimize the risk. We try to have the policies in place. We try to do training, but these are the potential sources of litigation that an employer can expect to potentially see a claim. Whistleblower, huge. Wage and hour, huge. I've seen wrongful termination, but only in connection with a severance agreement and a threat that you've wrongfully terminated me. It's not a huge claim because we're an employee at will state. But retaliation, like, oh, I complained about this a year ago and now you're firing me because I'm the one that got, that you got rid of. The biggest thing with all of this with COVID from the very beginning, whether you're opening your workplace or you're addressing issues or you're letting people go, is talk to your employees, make them part of the process, but don't make any assumptions. So much of what I do is, even with reopening your workplace, is, well, we can't bring Bob back because, he had cancer 5 years ago. Well, don't make that assumption. Don't talk to your employees. Bob might be the first one to go, I got to get away from my spouse. I got to get out. I want to come back to work. You just don't know. So don't draw conclusions that you could be horrifically wrong on and open yourself up to liability. Make your employees part of that discussion, and you will be surprised and welcomely surprised at some of the solutions that they come up with. So I offer this. We went through a lot of policies. My office put together a toolkit way back in March, and we continue to offer it at a discounted rate for any presentations that I do. It's $300. It has all of these policies in it. They're all Word documents. They can be crafted for your businesses. And a summary, you get all the orders and a summary of what all the documents mean, and you can tailor them and put your logos on them and for however you need them. So it's a huge time saver. It's updated regularly. As you can see, there's a vaccine policy in there for mandatory and voluntary. So a lot of what we covered today, these policies are in there, or if you need help with revising your handbook, like I said, we do that too. We have a ton of them that we're working on right now. So I'm here as a resource. I'm here to help. I'm here to work with you and your clients as you need them. That's all I got. Oh, and please link in with me, connect with me. And also I do a blog. I promise I won't overwhelm you. Beth can attest, I really don't put a whole lot out there, but as I see things that are really significant to business owners or people that work with business owners, I put them out there on a blog. If you get a couple a month, it's a lot. But it's more like, hey, business owner, you need to know this just came out, and here's why it's important to you as a business owner. So if you want that, you can email me or go on my website, and there's a little button that says subscribe to my blog, and I'm happy to put you on the list. And that's all I have. So I know that's a lot of information, and your eyes are probably rolling back in your heads. But happy to answer any questions.
Any questions for Tina? This is not a shy group, so I'm kind of surprised.
No questions, but very helpful, and thank you very much.
You are very welcome.
Beacon is the premier executive networking organization serving the Mid-Atlantic region. To learn more, go to beaconforlife.org.